Okay, next, we'll have our Law and Licensing Committee report, and Committee Chair Carol Lear.
Are you ready?
Yep.
We had several action items and a few changes within them, so I'll try to be succinct, but give you a little sense of what happened in the committee meeting. So the first item is item 10.2, and the discussion was about R277-715, out-of-school time program standards, which was for amendment and continuation. This is a program that is a joint program between USBE and DWS, Division of Workforce Services, and has been alive for a couple of years, I think, but they wanted to add an external quality assessment tool as part of program monitoring. So they needed they needed to amend the rule. We needed to amend the rule. So everyone had heard from those folks involved and agreed amendment was appropriate. The motion for the board is that the committee moves that the board continue and approve R277-715 out-of-school time program standards, draft 2 on second and final reading.
Okay, the motion before the board is that the board continue and approve R277-715 out-of-school time program standards, draft 2 on second and final reading. Discussion to the motion. Board Member Earl.
Yeah, my question has to do with just the actual measurement tool and then the privacy of the individuals and the data that's collected. Was that addressed at all?
I don't recall, and Angie was there. She might be the best person to speak to that, or whoever chair you would like to invite.
And maybe with
Angie, do you want to
that,
bring up?
what do those observations look like, I guess? And that would maybe answer the privacy too, but.
Education specialist. I help oversee this grant program. So the observations are from a nationally validated tool that comes from the Weichert Center. It's called the Program Quality Assessment Tool. And the trainers or the observers go through a rigorous training at the national level before they ever go out to observe a program. And it's very focused on the experiences of the youth in the after-school program. So, how are the staff engaging the youth and building those relationships with them?
So it's broad, not, it's more of a broad understanding,
Yes.
not specific for student time.
Yes, it's
Okay,
very
okay.
broad of the after-school program itself.
Sure, that's what I wanted to know.
Yeah.
Excuse me. Is there any questions or comments regarding the motion? Well, seeing none, the motion before the board is that board continue and approve R277-715 out-of-school time program standards, draft 2 on second and final reading. All in favor say aye.
Aye.
Those opposed? Voting was unanimous. Please continue, Chair.
Item 10.3 was just a discussion item. We spent an hour, I think, talking about third-party provider contracted services issues. We had participation from a number of people, including from members of other committees, and we very much appreciate that, and it will be back again for further discussion in December. Item 10, so there's no action on that. Item 10.4 was another rule, R277-613, LEA disruptive student behavior, bullying, cyberbullying, hazing, retaliation, and abusive conduct policies and training. And this was for an amendment and continuation. And the primary purpose of this amendment, as I recall, was because the board had added, the committee and then the board had added another piece or descriptor for bullying that was not outlined in the law. And so the staff were summoned to the Administrative Rules Review Committee, where they discussed this addition and eventually decided to remove it. What I would like to know, Angie, remind me, and Jenny had asked me to, and I didn't know the answer. What was the objection from the individuals and members of the Administrative Rules Committee to the language that was added, which was about relational aggression and indirect or covert or social aggression to be part of the definition.
Thanks. Thank you. Angie Stallings, Deputy Superintendent Policy.
If that's okay, if I
You
can ask her that. I
Well,
didn't
you
ask.
can, you can ask, but we don't have a motion on the table, but
Oh.
we're a little bit out of.
Oh, is that
sequence,
out of
but-
order?
Well, I
Okay,
think so,
you want me to
but-
put the motion up first and then have Angie speak to it?
Yeah, that would be in order,
Okay,
so,
let's do it in order then.
thank you.
So there was discussion, and the final motion for the board is that the committee, move that the board continue and approve R277-513, LEA disruptive student behavior, bullying, cyberbullying, hazing, retaliation, and abusive conduct policies and training, draft 2, on second and final reading.
Okay, I'm just making sure the numbers are right, but I think it's 613, is that?
Yes.
Okay, got it. Okay. The motion before the board is the board continue and approve R277-613 LEA disruptive student behavior, bullying, cyberbullying, hazing, retaliation, and abuse conduct policies and training, draft 2 on second and final reading. Discussion to the motion. The chair, you have a question? For Angie for clarity.
To put it now more succinctly to Angie, the change is largely because of an objection that members of the Administrative Rules Committee had, and I just would like Angie to explain, Deputy Superintendent Stallings to explain to other board members and remind me what their concern was with the language that our specialists thought should be added.
Okay. Will you please respond?
Yes. So you can see right there the changes on lines 36 through 38, that those 2.5 lines are what the committee was objecting to. So you can see in 2A, we just simply say bullying means the same as that term is defined in statute. And then they objected to us adding those 2 lines because it wasn't comprehensive enough to explain, I think, that the relational aggression is only generally, there has to be a pattern of severity or pervasiveness generally, and it's about this, how the person who is receiving, on the receiving end of the relational aggression perceives it. So they felt like it was too subjective and could violate students' free speech rights. So if a student is being intimidating or spreading rumors or, isolating students, and then they were caught or it was labeled as bullying and they received some sort of penalty, the people who were advocating against this language felt like that violated the student who's intimidating or doing the aggression. It could violate their free speech rights. We looked at potentially amending the language somehow to include the severe and pervasive test in there, and at the end of the day decided to it would be best to just strike those 2 lines. And then in subsection B, there is some clear statutory authority for the board to include those lines, so they didn't object to that. So that's essentially it.
Okay. Board Member Jenny Earl.
Yes, I have a question on 3 lines. So at 255, we already have data we're collecting that we're instructed to collect. And then at 255, it says the number of incidents described in 8D that include a student who is bullied, cyberbullied. So what are we doing? Are we not already correcting this? Are collecting this? We're collecting additional data because we're asked to collect data under these other areas here. I'm just trying to understand what that terminology means.
Yeah, let me look real quick.
Okay,
Can you
that's fine.
repeat the lines real quick?
255, 256,
Yes, thank you.
257.
Yeah. So to clarify, yes, so the term bullying, now we would look to the statutory definition as well as what it says there in B. There's another section of the code that talks about that, that whether or not the person receiving the bullying, whether they've consented to it or not, it's still bullying or hazing. But you're right, now under 249, the reports, yes, we should be receiving reports on the number of incidents, but now it would be limited to the incidents that fall under the definition of bullying in code and that 2B, not the old 2B. So is that helpful? Yes,
Have a
we are.
follow-up?
Yeah.
Okay, so this is new information we're gathering, and you're saying it's linked specifically to request?
Well, we've been gathering this data for a while now, so it's not, and there's nothing new in this rule
Okay.
other than the deletion of those two lines, 36 through 38. So I guess based on the deletion of those lines, there might be less incidents that we're collecting because now we would no longer be necessarily collecting incidents related to relational aggression. And unless, if you looked at the definition of statute, and I apologize, this
That's okay.
becomes overcomplicated and I don't want to go on too long, but emotional harm is included in the statute. A lot of what you see in B there, those lines, are just examples of emotional harm. And so honestly, a lot of this will still come in because under the definition of emotional harm, a lot of that is included in emotional harm. It's just, they objected to us making the definition larger than what they had in statute.
Okay.
So the question is, I think might be, if I was hearing your question right, are we collecting more, are we collecting less, are we collecting in addition to other
Yeah,
forms
that's-
of data? Is this another new?
No, if anything, we might be collecting less based on this amendment, but it's just a continuation of continuing to collect incidents of bullying as defined in statute. And then whether or not it was consented to or not doesn't negate the fact that there was bullying.
But I think, if I might have this wrong, but is there more in addition to stuff that we're already doing? And that was, you were after kind of
that
like
is
a
what I was
yes or
looking
no,
for.
or it's still the same?
It's the same.
Okay.
Okay.
Aye.
I'm
Thank you.
thinking, is that was kind of where your question was?
Yeah, I was just.
Okay.
Yeah.
Board Member Scott Hansen?
So just, the school safety audit had a bunch of requirements for reporting this type of data. Has this been cross-referenced with that at all, or have we tried to tie the two together?
Yes, I mean, so the school safety data, a lot of that is related to discipline and how law enforcement, school resource officers, or other administrators potentially are disciplining. This, generally, the bullying is more about student versus student. And yes, if there were bullying occurring, it could result in discipline. To answer your question, yes, we have been looking at all of the data we collect related to discipline comprehensively and been trying to improve the data at collection, either through our systems or through training. But as you know, from the audit, there's still a lot of work to be done on our end.
Yeah, could I just
Okay,
follow
follow
up?
up.
So have we made any effort in these rules as we revise them to make sure we're picking up data that should be reported that's required under the, so that's,
Yes.
we're consciously doing that?
This rule is kind of a subset of conduct that might trigger discipline. I think Rule 609 talks more about discipline, and then we do have a rule that's specifically related to that, SB 198, for example, that just requires data to be submitted. But the question is, as you know, we found that a lot of that data, there's no way, at least perceived way, for our LEAs to get that from law enforcement and vice versa. They are not. So then the school district and charters don't have the data from law enforcement to then provide to us. And that's what we are planning to work on this session. That's one of the board requests for changes that we presented to you, to work with potentially Senator Andrade, since he was the original requester of that bill, to fix either allowing us to have better communication between law enforcement and our districts so that they can report that data to us, or to potentially find other ways, systematic ways.
Okay, thank you.
Okay. Board Member Hansen?
A question for Angie, if that's okay.
Yeah.
So we worked on this for a couple of years. Seemed like it was never going to end, right? And so the things that we're taking out were all things that were helping LEAs define what bullying was, because they were all defining it differently, right? And so is this going to affect, I mean, how is this going to affect our LEAs and our data collection, I wonder? Because the reason why it was in there is because when we were getting data, it was just, I mean, some people were saying, some LEAs were saying they had no incidents of bullying, and some looked like they had a whole lot because they were using different criteria.
Yeah. So thank you for that question. These lines explicitly were requested by an LEA administrator, a school district administrator that served on the bullying prevention work group that then made recommendations to the Law and Licensing Committee back in the day. And the reason the recommendation was there is many people they have a trouble identifying what emotional harm looks like. Because physical bullying is a lot easier to identify and see, versus emotional harm or emotional bullying. So there was a request to add some examples of what emotional harm or emotional bullying would look like. The Administrative Rules Committee, Review Committee, essentially said that if we don't take out these lines, they won't include this rule to be renewed. Or they didn't take a motion because they didn't have enough people there, but they, what the Administrative Rules Review Committee does is if they don't want to, not sunset, help me somebody, what's the word? Reauthorize. They reauthorize all of the administrative rules every year, and one of their powers is in that bill during the session to reauthorize. They could just say, except for the board's R277613, it's essential, they could just repeal it. And, but to make you feel better, if this will make you feel better, our model policy does include these terms and does give those examples. And Corby Eason, who's our prevention specialist, has told me that he will include them in our training, so.
One more question.
Okay, follow up.
So as I'm thinking about this, and I don't know if we talked about it or not, but we talk about emotional harm. How do we determine whether a student who doesn't speak has been emotionally harmed or bullied if he can't tell us that he has?
Question. And I don't know that I'm the best person to answer, but
Because we know that our special needs kids get bullied at least 3 times more than anybody else. But how do we know if they're being bullied if they can't report it?
Board Member Jenny Earl?
I think Linda asked a couple of my questions are along the same lines, but common data sets then, every district, we have definitions, but they have common data sets that they're entering in. Is that accurate? That's the reason why we're collecting it, so we can have common information, right?
Yes.
So someone's not.
One of the reasons.
Yeah, but someone's not speculating on what certain, not what they mean, but they're entering it in a certain way. Does that make sense? Right? Because if we're collecting the data, we want it to be, okay, so I'm just confirming, we've got common data set kind of
Yes,
thing, okay.
yes.
Okay.
Board Member Cindy Davis?
I noted this in committee, but I just kind of want to, on public record, say this also. We felt like we needed to make the change so that the rule could be reauthorized, and we at least had something. But the concern was expressed on the Hill that we could be violating the free speech rights of some. But I feel compelled to publicly note that we also have a responsibility to protect children while they are in our schools. And I just want that on record somewhere, that that is said and understood.
Okay. Board Member Chair Lear, are you going to comment on this?
I have a comment that should have occurred to me the many times I've read this, but yes, in addition to bringing us to a conclusion.
Okay. Well,
I
when you're
had
done,
a-
I'm going to repeat what's the motion, so we know where
After
we're
that.
at. Yes.
Right. I'm concerned, I thought one of the concerns about this rule, and one of the things that was going to happen were to try to bring some consensus, some consistency to the reporting by LEAs. And so I'm concerned, I'm looking at line 248, and it says that a policy has to include, an LEA's policy has to be posted, report the following annually to the superintendent, a copy of the policy, and then incidents of bullying, cyberbullying, hazing, retaliation. I'm still concerned that we have the problem we've had for 20 years of if 4 children are involved in a retaliation incident and 2 of them are the prime movers, do you report 4 incidents or 2 instances? And I think we're going to have the same, until we put this in the rule, some common information, that you're going to have the same disparity among LEAs in their reporting, and it's going to be as unhelpful as it's always been. So maybe that's something to keep working on, Linda, for the next 2 years. I just think we had an opportunity here, and I missed it too. So I just think
well,
we need some
Here's-
commonality.
This is where we're at on this, is there's a couple options, and you're chair of the committee, is something came out of your committee, has come before this board. We're having somewhat of a committee discussion here, but this is healthy discussion. Is this necessary that this has to be moved forward with a continuation now? Is this a time-sensitive thing, or we have a motion before the board and somebody wants to have it go back to committee but it's not going to get fixed here with all these concerns and all these different questions. So,
Chair, can I ask
you bet.
in a different form? Can you give me any assurance, am I reading this wrong, or is that concern a valid one in your mind, or in Brian's mind, Mr. Olmsted's mind, who's been working on this, or Corby's mind, who's been working on this? Is that a legitimate concern, or am I over-processing this?
So you're asking for
I just didn't-
an opinion here, and somebody might give you
Syntax.
one that's.
Can I just rephrase what I think is the concern, just so
Yes.
that I make sure? I think what Board Member Lear is stating is that we talk about the number of incidents, but the question is what constitute an incident? Is when you have 4 students involved in one incident, are LEAs uploading that 4 times or just 1 time? And whether or not this rule could or should be clarified.
help us.
To clarify that. So, do you know if that's an issue, or if there's?
Maybe you don't have an answer.
I have an opinion.
Oh, well, so do I.
So Brian Olmsted, student coordinator, or student support coordinator. I think it's a training issue. I think is what we're talking about. My opinion would be that the rule wouldn't define that, but our training would, and how incidents get recorded. Because what I would see is a single incident with multiple individuals involved, perpetrators, victims, and so it's a single incident.
And so you only need to call it one bullying
Right,
incident
right.
versus 4 or
And,
4.
and we have the methods to record it that way. We would just need to train so that it's, to have consistency in our data.
That's helpful. Thank you.
Yeah.
And so if I can respond briefly, my druthers as the chair of the committee and one of the people who brought this concern forward is that we do this for another year, given what we have here and given the training, subject to the availability of funds, that we see if we can bring more consistency to the reporting. And then if we find the same disparities we found for a long time, that maybe we'll look at putting some more specifics in the rule. Is that a fair thought? Okay.
Everyone's nodding their head,
So
but
we're
we
good.
have that in every rule we pass, too. We can always bring it back if we see
Yeah,
something
true.
that we want to do.
But
So
but
it's not unique to this particular
No.
rule.
Well, although this is one that we've
So the
tried to
que-
get consistency on for
So the-
100 years,
so
and we're
the-
not there yet.
So the challenge is, somebody's got to remember to bring it back, somebody's got to evaluate the process, and so
Yep.
until we have a mechanism to put something with some kind of time constraint to bring back in 1 year, it'd be, I think,
I just,
but I'm just stating the obvious, unless there's something different to bring back,
we'll just
to
try and
limit it
remember.
to, so that, okay, we're still speaking to
The motion.
to the motion. So, Board Member Scott Hansen.
If I can speak to that, I think, given what I've heard about the reporting and what I know about that and the opportunity we have now to get this out, I think this is the chance to send it back and put a definition for incident in the rule so that it's clear. We don't have to rely on training that may or may not be communicated properly to various people, and then we'll get good data. We don't have to wait a year. We don't have to bring it back.
Okay.
If there's no driver to have this out right now, let's send it back to committee and fix that. That would be, and I'll move that we do that.
Okay.
Sorry, I did it again.
No, you're good.
Spoke and made the motion.
You're in good company, Scott.
Okay. We have a motion. Do we have a second?
I second it.
We're going to send this back to committee.
I can't believe
Not
this.
seeing any discussion on this motion. All in favor, say aye.
Aye.
Those opposed? Okay, voting is unanimous. Okay, please continue.
The next item, 10.6, is another Rule R277-609, Standards for LEA Discipline Plans and Emergency Safety Interventions. It was to be amended and continued. The changes were to reflect current best practices, and it had to do, this is another ongoing concern we've had about restraining students, both in the special ed terminology of restraint and also in the just restraint of students without disabilities. And finally, I think the staff did a good job. I'm not yet convinced that it will be implemented quite as meaningfully as we intend, but willing to try. And it clarifies how long a student can be restrained and how that takes place moving forward. So the motion for the board is that the committee moves that the board continue and approve R277-609, Standards for LEA Discipline Plans and Emergency Safety Interventions, Draft 4, on second and final reading.
Okay, the motion before the board is the board continue and approve R277-609, Standards for LEA Discipline Plans and Emergency Safety Interventions, Draft 4, on second and final reading. Discussion to that motion, Board Member Linda Hansen.
Hi, I have an amendment.
You have an amendment?
It's posted, yeah, for people
Okay.
to see. It's on lines 248 through 253.
Okay, that's,
So I move to amend line 249 to read, "More than the shortest of the following before stopping, releasing, and reassessing the intervention used." If I could speak
it's
to
easier
that.
for me to read it here than.
There you go.
Is there a second? Second. You want to speak to your motion? To
I
your
do.
amendment?
When I read through this, I was a little concerned that the reassessing the intervention used part was added, and I was a little concerned that perhaps somebody might be physically restraining someone and then just turn to a person next to them and say, should we continue on as the reassessment instead of stopping, releasing, and then reassessing. And so I thought, oh, maybe this could go on for a long time, really a long time. So I was concerned about that. So I called a few people on the committee, and I called Terry Shoemaker, and it seemed like the consensus was that everybody thought that what they had voted for they would stop and then release them and then reassess. And so this is just a clarification so that everybody's kind of on the same page that before they reassess, that they stop and release them. I think if we don't, then we could have children hurt, we could have staff members also hurt, because I know that was one of the reasons why we originally did this rule, was because we had staff members being hurt all the time from being physically restraining kids too long. So that's kind of why I've got this motion.
Okay. We have a proposed amendment. Speaking to the amendment, Board Member Scott Hansen.
Got to find the lines, just one sec. 244, 245, and this is going to the timing. It says that a public education employee shall provide notice as soon as reasonably possible before the student leaves school to the student's parent. I just wondered what happens in this scenario where you can't get a hold of the parent, you can't contact them. And then school ends, say
Okay,
this
you're
happens
speaking,
at 2:30.
you're speaking to the overall rule or to her amendment? Is that part of
I
that
am.
amendment?
Oh, not to-
I guess I'm going to the rule, but this, it ties into this, but I don't know. I can take it up
I think it's a
afterwards.
separate item because hers
Separate
is on
item?
the restraint process of when do you pause, assess, and then redo. So can
Okay.
we bring that back? Is that okay? All right, thank you. Did you have something to add? We're speaking to the proposed amendment. Board Member Cindy Davis?
I do think that this amendment kind of speaks to the intent that we had in the committee, and it may answer Board Member Hanson's, the other Board Member Hanson's concern as well. But if there is a prolonged time when parents, you can't get a hold of parents, in that reassessment, if a child is in danger of hurting himself or others, there may have to be some additional restraining, but that's the last effort, and you're not going to do that longer than 30 minutes. You're going to be continually releasing and trying other interventions as the first way to take care of that situation.
Okay, the proposed amendment is to amend the line 249 to read more than the shortest of the following before stopping, releasing, and reassessing the intervention use. I've not seen any discussion, any further discussion on the proposed amendments, so let's vote. Again, the proposed amendment is to amend the line 249 to read more than the shortest of the following before stopping, releasing, and reassessing the intervention use. All those in favor of the proposed amendment, say aye.
Aye.
Those opposed? Voting is unanimous. Board Member Scott Hanson, you had a concern in this rule on a particular line?
Sorry
Okay.
for speaking
We'll need
out
to
of-
try to find it.
Out of turn, yeah, it's, so it's 240.
Or a proposed amendment or just
Well,
a
I just have a
concern?
question first. So 244, 245, we're talking about the scenario where a child is, there's an issue, notice needs to be provided to the parents, and it says that needs to be done before the student leaves school. This happens at the end of the day. What do we do?
Jeff Van Holten, Policy Advisor. The idea here is we included the word provide notice so that it is the notice that is being done, not necessarily that you will actually get a hold of the parent. Notice can be provided through an email, it could be a text message, it could be a voicemail. You may not actually reach the parent and have a verbal conversation with them, but notice is being provided before the student leaves in that sense. So that's the
And
idea here.
Some of it's a hand, if I might intervene with this, it's even more than that. Sometimes it's a handwritten note fastened to or to the particular student or to another student to get, there's quite a few other ways of communicating. I don't think they use pigeons or anything like that.
So if I could
But that's
just-
the
if I could
intent
just
is,
follow up, just
yeah.
one brief. So the intent then of the notice is just to get the school's notification and version of events to the parents somehow before they hear it from the child first? Is that the idea?
Yes.
Okay.
May I just comment? Apparently, this is one of the number one complaints that LEAs and our office get, is when a parent hears from their child about an incident before the school contacts them. So I think this was very much a discussion in law and licensing also, this very issue you're addressing, which is why the language was changed from notify to provide notice for those instances. You know, best case scenario would be for a call, some interaction to take place, but if not, that the email or a text or leaving a voicemail message would suffice.
Okay, thank you. If I do have one more.
Okay.
On another section, if that's okay. So I'm looking at the end of it's 398, I believe, model policies. This says that we'll develop, review regularly, and provide to LEA boards model policies to address this. I did find a model policy on the website, but I wondered if we had looked at that as part of this update. It looked like it was fairly old when I looked at it, so maybe something that we can just direct staff to look into. And then also the next one, number 2, technical assistance to LEAs. I didn't find anything on the website for that, and I wondered what form that technical assistance takes. I don't know if anybody else.
I can, technical assistance as far as training in the schools has been taking place, as well as the LRBI least restrictive behavior intervention manual is provided, and that is essentially what the trainings are all centering around in terms of the technical assistance being provided. But additional resources, that's something we can also ask staff to look into in putting up on the website.
Okay, I appreciate that. I did see the LRBI manual that's there and accessible to everyone. I just wondered what else we were doing, so thank you.
Board Member Linda Hansen?
Just a couple of things. I know the model policies is a concern. When we first did this rule, Student Services was just getting up, and they were going to work on those things, and I think it's something that fell through the cracks. And so I think that's something that we need to be working on. I know the Disability Law Center is concerned too about the model policies. And then just a personal note about notification. You know, if my son, you guys know that I have 2 boys with autism. If my son's causing a disturbance at the school and he is being restrained, I want someone to notify me so I can go help, instead of having him go back in and out of
got 30 minutes, yeah.
restraint, you know? And so just, you know, for whoever, just for general information, and for the public too, the sooner you can notify the parents, the more help you'll get. So it's worthwhile, I think, to notify them as soon as possible.
The motion before the board is that the board continue and approve R277609 standards for LEA discipline plans and emergency safety interventions, draft 4 on second and final reading as amended. Board Member Lear?
We still have one more amendment. Thank heavens that Angie is remembering all of these. We had one more amendment that actually occurred to me after we were in the middle of this. In the definition of suspension on line,
I need a.
Starting on
I
line
need
111.
A motion to
the
amend.
motion is to provide
Amend.
another amendment to the definition of suspension.
So you're making a motion to amend, and we're going to go to the definitions, okay. And what would it be? What would be that?
On
amended
line,
amendment?
Line
The
112.
motion's right there. I move that we.
I- oh,
So, see, it's right here in writing, right here.
that makes it really easy.
So would your motion be that one that says, I move that we amend the
says-
definition?
Right.
Oh,
I
there
move
you
that we
go.
amend the definition of suspension by inserting the phrase "for another appropriate reason." My thinking, that's my motion.
For okay,
After
so
for
it's
a-
as written there. Is there a
Yes.
second to this? Second?
Yes, second.
Second? Discussion to this amendment?
Can I speak to that
You
now?
bet.
When I read this again for the 13th time, it occurred to me that suspensions occur for a variety of reasons, and if anyone cares if it's reported on a student's record, that sometimes the suspension is not only for a disciplinary reason, and we wouldn't necessarily want to put that on a student's record. We'd want to put the suspension maybe, but it doesn't necessarily need to signal discipline. So I wanted to add in another phrase that allowed for a suspension, maybe to investigate something where the student did nothing wrong.
Okay. Any other discussion to the motion, to the proposed amendment? Seeing none, the proposed amendment is that we amend the definition of suspension by inserting the phrase, quote, "for another appropriate reason," end quote, after or violation of school policies on line 112. Stating it right? Okay, here we go.
Does the inserted, they have to be after rules? Is that a typo?
Yeah, I think we got.
Okay.
I think we put it in a little bit the wrong place. In or out of school, or student assistance regulars for violation of school policies or for another appropriate reason. for any length.
for-
Maybe we don't
so
need
maybe-
rules in there at all.
Maybe we,
Okay.
do you
Is
have
this-
this electronically?
I do.
I want to state the amendment so we
Yeah,
can
just
vote on
take
it.
rules out.
And then we can amend it.
I'm going to have Vice Chair Brittany
Oh,
Cummings
school
read.
policies or
Read the
rules.
proposed amendment.
There we go.
There you go. There it went.
Not meant to be, I guess.
Oh, thanks.
Suspension means a temporary removal in or out of school of a student from the student's regular educational setting for a violation of school policies or rules. Or you just moved it to the end?
Well, I was wondering if we wanted to say from the student's regular educational setting for any length of time due to a violation of, or,
A violation of
another-
school policies or rules. It's the rules it's missing, it's in the wrong spot.
oh, you're right, I see now.
Yeah, that's what,
Yeah,
I didn't see it either.
okay, thank you.
Or for another
Yep.
appropriate reason.
Does that work?
Yeah, for any length of time's kind of hanging out there, but
Maybe to make it clearer, do it this way. Is that better? Then we don't have so many ors?
sure.
So let me see if I can read it. Under 25, suspension means that the temporary removal in or out of school of a student from the student's regular educational setting for violation of school policies, rules, or for another appropriate reason for any length of time. Ooh, lots of thumbs
catch.
up in the back, so.
Lots of
Okay.
Thank you.
lot of
I-
prepositional phrases.
So is
That's
that, are you
great.
still good on the second, whoever seconded?
Yeah, that was Jenny.
Okay. So discussion, Board Member Hanson?
Yes, she's-
Just a question. So if
Linda?
a student breaks a rule and the teacher takes them out into the hall to talk to them or sends them out in the hall for a minute, then it's a suspension. According to this.
Not the sense of it.
Yes, you're temporarily removing them for any
From the student's
length of
regular
time.
And they're trying to get to in-school suspension, so, yeah. But that's the way it reads, I agree.
So what your question is, does that mean a suspension when you remove them out of class and have a talk with them in the hall? Is that your question? Does that define a suspension?
For a meaningful length of time. For a, they're just trying
We have our
to,
AGs talking, shaking heads. So Vice Chair Brittany Cummings, did you have a question or comment?
And I would just add to Board Member Linda Hanson's comment, so even if we add like a length of time to it but for any other appropriate reason would include like a parent removal of class. And so just being really cautious, words can be dangerous sometimes.
you know what,
Yes, Board Member Lear.
let's do this. Let's go on, finish this, and then let these guys work on this for a minute, because I think we need a good definition of suspension, because sometimes the definitions are cited by parents who have concerns about their children's educational program. So I think we need a definition that is accurate.
Okay, we're going to put this on hold,
And
this
yes.
amendment,
Yes.
briefly, not.
Not forever.
Not forever.
Not for any
And
length of
I'm going to
time.
invite you to go back to the rule, the rule that you skipped, Rule 277609, which was 10.6.
Yeah,
Can we go to there?
yes, and I've got one more I skipped.
Okay,
I've got two more I skipped. One more I skipped.
hold it.
Go
Go into 10.6.
Yeah, 10.5, item 10.5. We'll go to that, and then I'll go to the end, and then we can come
Oh, we
back.
skipped two.
No, well, two motions within 10.5.
Okay,
So,
10.5.
item 10.5, R277-324, paraprofessional, paraeducator programs, assignments and qualifications, which is a new rule, and R277-524, paraprofessional, paraeducator programs, assignments and qualifications. set to be repealed. So the first motion for the board, the committee moves that the board approve R277-324, paraprofessional, paraeducator programs, assignments, and qualifications, draft 2 on second and final reading. Can I speak to that?
Okay, well, let me repeat it first.
Oh.
The motion before the board is that the board approve R277-324, paraprofessional, paraeducator programs, assignments, and qualifications, draft 2 on second and final reading. Anyone want to speak to the motion?
This is
Chair
just a
Lear.
renumbering of the rules related to licensing. So we need to pass the first one and then repeal the old one.
Okay, any discussion to the motion? I'll repeat the motion, then we'll vote. The motion before the board is to approve R277-324 paraprofessional, paraeducator programs, assignments, and qualifications, draft 2 on second and final reading. All in favor, say aye.
Aye.
Those opposed? Okay, voting was unanimous.
Second motion for the board on the same rule. The committee moves the board repeal R277-524, paraprofessional programs, assignments, and qualifications.
Okay, the motion before the board is that the board repeal R277-524 paraprofessional programs, assignments, and qualifications. Any discussion to that motion? Seeing none, let's vote. All in favor, say aye.
Aye.
Those opposed? Voting is unanimous.
And then the final item,
But
item 10.
the final before we go back to the one.
Before we go back to
Yeah,
to
so
the
10.7.
second to last final.
There you go.
Item 10.7, this is another rule, R277-472, charter school student enrollment and transfers and school district capacity information. This is an amendment. And the motion for the board is that the committee moves that the board approve R277-472, charter school student enrollment and transfers and school district capacity information, draft 5, on second and final reading.
Okay, the motion before the board is that the board approve R277-472 charter school student enrollment and transfers and school district capacity information, draft 5 on second and final reading. Discussion to that motion. Board member Cindy Davis.
I'm going to vote in favor of the motion, but I do want the board to be aware of the conversation that we did have within this rule. And we were looking at a neighborhood school can declare itself full on June 30th, I think was the date. We were looking at moving that date up to April because hiring is done and over with, and we're hiring and not knowing our definite numbers. And I went to the charter directors meeting and picked their brains a little bit about transferring in and out and what they are dealing with. And they said, one charter director said, we have so much attrition, we can have a certain count on one day before we hire our staff. And then when the school starts on the first day of school, we can have differences of 60 students. And I think that there is a larger systemic problem. And everybody says, well, it's just the parents. They're going to do whatever they want. They apply to lots of different schools. They move in and out. And we're just going to hire all these teachers that we may not need and have all this double spending of money. And I just say, you know what? If there is a way in policy that we can help assuage this problem and mitigate these problems and then communicate what's happening with parents and beat that drum for the next 10 years, maybe in 10 years, the problem will be better. As a parent, if somebody explained to me what you're doing is hurting our public education system as a whole, I would make some changes. I would make a decision by March 1st and stick to it for the next year, and then the next year make another decision. But that's just my 2 cents. I think we do need to pass the motion today, but it's something to look at more holistically in a larger picture.
Okay, the motion before the board is to approve R277-472 charter school student enrollment and transfers and school district capacity information, draft 5 on second and final reading. Any more discussion? Okay, seeing Board Member Jenny Earl.
Yeah, so Cindy, I guess we could revisit this down the road. I'm just curious if we're going to end up with other problems associated with this, and hopefully we won't. Hopefully you're right, if we create a deadline, sometimes people, even if it doesn't need to be in for a while, you say 2 weeks, they'll get it in 2 weeks even, so I'm hoping that's the case. So I hope we can revisit this if there are concerns that come up or issues associated not only with parents, but also with schools themselves where, kids aren't able to get into things if there's, situations come up, so, yeah.
Board Member Cindy Davis?
Yeah, with this particular one, we haven't changed anything, it just is code. We didn't go back and change or make any dates earlier. We should, probably. I've heard from charter folks it would help them, I've heard from district folks it would help them, but I think we need to look at it more systemically.
Okay, I'll not seeing any discussion, so we're going to vote after I restate the motion. The motion before the board is the board approve R277-472 charter school student enrollment and transfers and school district capacity information, draft 5 on second and final reading. All those in favor say aye.
Aye.
Those opposed? Voting is unanimous. Are we back, we have that definition. I'm going to bring us back to R277, 609 amendment, second amendment. That definition that Board Member Lear started on. So what would be the proposed, do we have a proposed definition?
We do. And Angie's just pulling that up really quick. What we added on the first line, you'll notice suspension means a temporary removal for a disciplinary purpose in or out of the school of a student from the student's regular educational setting for a violation of school policies, rules, or for another appropriate reason for any length of time. Really specifying that it's the disciplinary purpose that is the reason for the removal in or out of the school setting.
I'll let board members look at it for a second.
I think,
I don't have a motion on this, but I think we can get right into the discussion if there's some issues with this, and then but it's not that. So I've got to go back to the person that made that motion.
which was me.
Are you
Right.
satisfied with this motion?
I think the idea, is that a yes or no question, or can I speak to that?
We can, with,
Can I speak to it?
yes.
I think the idea is that now, for disciplinary purpose, is supposed to modify temporary removal. Removal. And I think that's kind of it, but I don't know that it would be read by everyone that way. So I need to hear what others have to say. I think I'm okay. It's better.
Okay, do you want this to be your motion
Yes.
for starting to do it?
I do.
And who did have that the second? Do we still have a second so we can get this back on the,
Jenny did, yes, she said.
Jenny, okay.
She said so.
So we're going to speak to this. I just have one quick question, and I'm going to take the privilege, while my light's on here. Suspension means a temporary removal for a disciplinary purpose in or out of school. So in quite a few schools, they have different programs. So you're in an elementary school and Johnny's being naughty and he gets sent to the skill center. He's being removed from the classroom, which happens to be his regular educational setting. Is that, by definition, that is a suspension, the way that I'm reading that. I don't want it to be a suspension, so every time Johnny gets in trouble and goes to the, I mean, that's what it says right here. Am I reading that wrong? So it's every time
That's a good point.
Johnny comes out, which is several times, depending on whether he's on, his blood sugar's fine or he
So what do
ate
you wanna
or
say for
whatever
them?
it is. And
So how do you?
so I'm not, that's my concern with this.
And this wouldn't matter, except that these are being reported, that that's part of the data collection, right? No, they're not, but that's what I'm saying.
It's getting into operations of a school, and this happens.
Yeah, we want to know how many suspensions there are.
Okay, Angie.
I just wonder, and I apologize, but wouldn't that be more of an intervention of trying to direct educational, not necessarily a suspension?
Well, by-
But I don't know that it meets.
Yeah, but that's not saying, that's saying suspension if you, what makes that happen.
Unless the
is
teacher
this.
calls it
But,
an intervention.
but is that discipline, I guess, versus saying, we're going to try this instructional?
What's the difference
I don't know.
between suspension and?
I,
Can it- you know, in the interest of time, Cindy, well, let's hear what people have to say. Let me go through the queue. Scott Hansen, sorry, I took my time.
No, that's okay.
The
Thanks.
privilege, sorry.
And I think I'm along the same lines. So we have discipline or intervention, then we have suspension. And suspension is something that carries some weight, goes on a record potentially, can have an impact on a kid's educational record. I think that needs to be more, I mean, it should be a day or a half day where they're taken out of their normal class routine and they're put somewhere else. So, yeah, and says this is suspension, and then there are some due process things. I mean, if somebody's suspended for multiple days, they can go and appeal that, I think, and say, hey, I shouldn't be suspended, but that can't happen if it's an hour or something like that. So I think we're talking about a day probably is the minimum for a suspension. I think the EOC has some definitions that go with 504s and IDEA that state a half day or a day. So, and most of the stuff I'm seeing on the internet is talking about more than a brief amount of time. So I would like to open the discussion up to maybe having this be a day of school as a suspension, and something under that is a disciplinary or an informal discipline or something like that.
do a lot of in-school suspensions.
Angie?
So I hate to speak for Nate or others, and Leah, if I say anything wrong, please correct me. My understanding is that one of the issues that we've had reported from IDEA that people don't understand, sometimes when they ask or they tell a student you have to leave for the day, they call the parent and say, essentially, at 10 o'clock or 11 o'clock in the morning, you must take your kid home. And they may do that repeatedly, over and over and over again. And the question is that a suspension when you're telling the child you're no longer welcome in the school? And it happens repeatedly, and right now, that is exactly the issue. A lot of schools don't recognize that as suspension, but for purposes of IDEA, the student is missing educational time by being removed from the classroom repeatedly for 3 or 4 hours. It might not be a full day. So I think that's one issue they're trying to get at, that if you do say one day, you're going to miss these reports of potential, like a school that isn't managing maybe how they're providing services to that student, and the way they're doing that is by telling the student to leave half of the day more than once. Is that right? So I just wanted you to have the background of why suspension, I think what we would want and what the Department of Education would want reported for purposes of we receive funding under IDEA is to track whether certain students are repeatedly being asked to leave campus and not necessarily for a full day.
Which still speaks to my particular concern. There's interventions that happen where this portion of the day, or from here on, they're in like a skill building center, or they're in another place, but they're removed from the classroom to work on skills and other things to be able to come back, and it's like an in-school suspension, I guess, but how is that defined? And the other part, the challenge that I see with this is that parents that sign up and say, okay, yep, I like that, but if for some reason it's viewed as a suspension, not an intervention every day, they're gonna say, no, I don't want that. Whatever I can do to get that suspension off record. I know I'm grasping, but this happens in a lot of schools where there's the intervention piece, and I don't see it clearly defined, but Vice Chair Brittany, comments?
Can this definition go back to committee? Is there any problem with moving this forward? Because I really don't think this definition is anywhere close to being ready, and I don't think we're going to resolve it today. And so I think this definition needs to
Yeah.
have some
Yeah.
time.
I agree. Let's do
Do it.
that. Is it need to be continued?
I would just say that this rule has needed to be updated for quite some time, and staff is waiting for the rule to be adopted and approved so that we can update the model policies. But we could take out the definition of suspension. Currently, the rule does not have a definition of suspension. It just mentions suspension. So if you wanted to, we could delete the definition of suspension for now, pass the rule out, and then bring it back just for the definition of suspension.
Okay.
Or is that bad?
Is suspension used in other rules, and should this be in 100? Is it 100? And so
Yep.
could we
We
bring
could do that.
100 back and have this fun conversation?
Yes, we could do that.
Let's do that. That's good.
So,
Oh, well.
No,
then-
just leave it.
Right now, we'll just leave it
Yeah,
out.
just delete the lines. Let me get to the lines. Sorry.
Okay, we're working through this. We're trying to follow Robert's rules. We have a motion
Just gotta
to
get to the actual rule.
amend it. Are you still good with that, or do you want to change your motion to say, let's take suspension?
No, I think that's a good, suggestion, motion, is to remove the definition of suspension and come and bring this definition back and pass the rule.
100.
Okay, do we have a second? Second. Okay, is there any further discussion? Yes, Cindy. Trying to, there it goes.
I'll speak to the motion. Having worked in administration at elementary school, junior high, and senior high school, when you suspend a student, it's for usually in-school or out-of-school suspension, half a day or more. And you document it as a suspension. You contact the parents. They understand it's a suspension. I would hate to have a kid who is constantly struggling that you may have to take out, or you have a special plan or part of a behavior intervention plan, or, and then all of these suspensions are clicking up on those records. I think we need to be reasonable, and I don't think there is an educator out there that considers interventions suspensions. They're different things.
Right.
Thank you.
Leah may have more to add on that, but based on my experience.
But
Let's
you're
vote,
okay.
let's vote on this amendment to take the definition of suspension out. Are you guys ready for that?
Yes.
Okay, all in favor, say aye.
Aye.
Those opposed? Want to leave it in? Okay, so it's all ayes with one no.
Obviously.
All right.
With that motion, we're going to direct staff.
Well, it's already noted, so we put it in our queue and we'll get it done. So what we have before us is the board continue and improve R277609 standards for LEA discipline plans and emergency safety interventions, draft board on second and final reading as amended. Note the amendment was Board Member Linda Hanson's amendment. Is there any?
Oh, this is an amendment too, as
I know,
amended
but this
twice.
is, but now it's still as amended, so.
As twice amended.
Is there any,
Got both amendments.
I'm not seeing any discussion, so let's vote on it. All in favor, say aye.
Aye.
Those opposed? Voting is unanimous. I think, Board Member Lear, that concludes your.
I think that concludes the committee report.
Are you sure?
Okay.
I don't think I skipped anything else.
I think we've only just begun.